Right? Just an overview to begin with. I'm going to tell you where the data that we have comes from. I'm going to give you a bit of a summary on how our system works. I'm going to talk with you about our filing volumes and our dispute resolution process. And then finally come around at the end and talk to you a little bit about COVID-19. Not that it's having a significant effect on our day-to-day here, but it is affecting our numbers, and it's worthwhile to talk about. I've saved some time at the end for questions, but throughout the PowerPoint there are some slides where I prompt for questions. I'm happy to take questions at any point that somebody wants to unmute their mic and jump in. You can also submit questions by chat, and the good folks that are running this will maybe consolidate those or work with those and give me a shout out that somebody has a question. So use the process as best you can. Where does the data come from? I'm fairly proud of the fact that we publish an annual report every year, and our annual reports are all published on our website, which is noted for you in the PowerPoint. And so if you go to our publications page, all of our annual reports are right there. You can tell the cover's not very pretty. We put most of our time and effort into the actual numbers. The annual report is compiled by the OJCC actuarial team, which consists of me, and frankly me. So any error in the numbers, entirely my responsibility and my fault. I think we do a pretty exhaustive job of putting data out there for our legislature and our community as to what we're up to and how things are going. So just to give you a little bit of a summary of our structure, we are, I believe, unique. The OJCC in Florida is part of the Division of Administrative Hearings. We do not have any real regulatory function in the state workers' compensation system. The regulatory function is relegated to our Division of Workers' Compensation. They are part of the Department of Financial Services, which is a cabinet agency under our Chief Financial Officer. My organization is part of the Division of Administrative Hearings. We are a cabinet agency. My office is a gubernatorial agency, and so it really is sort of a mixture, a hybrid, if you will. And so I think we're pretty unique in the way our process works. We're subject to an awful lot of supervision from both cabinet and the governor himself or herself. I like to give as a foundation a little bit of a comparison who we are and how we are. Everybody knows that California is the biggest state in the union by population. Texas is number 2. I still periodically run into from time to time somebody who's surprised to learn that Florida is the 3rd largest state by population. We passed New York a couple of years ago, and things just keep on growing. So by rights, we probably should have the number 3 volume of workers' compensation judges to keep up with the traffic. California, by my estimation, and I haven't exhaustively researched it, but California has the most workers' compensation judges, and by a lot. We are nowhere near the top. Though we're the 3rd largest state population-wise, I've got 31 judges scattered between Pensacola and Miami, and we're handling the workers' comp claims for that entire population set. So it can be a bit of a daunting task. We do not tend to engage in a lot of attorney hand-holding. And I hear from judges in other states that there's a fair amount of status conference practice and discussion about where cases should go or how they should go. And frankly, we're just not in that business here. We're in the business of adjudicating disputes, and we see it as the attorney's or the party's responsibility to figure out what those disputes are, to define them, refine them, and get them in front of us for a decision. So that's how we manage to handle the workload that we do with the very, very small cadre of folks. Our entire agency is somewhere right around 170 employees. So that ought to give you a reasonable idea of how efficient we have to be effective. So if you rank those various judges in terms of the judges per population, we've got an awful lot of people that each one of us is responsible for. What disputes do we have jurisdiction over and what do we not touch? Our Division of Workers' Compensation handles all reimbursement disputes. So If the argument is about how much a doctor got paid or should have gotten paid, she can file a petition with the Division of Workers' Comp, and they will adjudicate that reimbursement issue. We saw that really explode a few years back with physician dispensing, lots of disputes. We saw that very significant in terms of the prescriptions that were doing the topical creams and things a few years ago. That has pretty well settled down. All of the other disputes regarding Florida workers' compensation, whether that's an injured worker that's seeking benefits, whether that's an employer that thinks some other employer or carrier owes them a contribution of some kind, whether that's an employer who thinks that one of our state funds owes them some support, our second injury fund or something like that, all of those disputes are going to run through the Office of Judges of Compensation Claims, and we're going to do our best to make those disputes move through the system. About 25 years ago, we moved from a claim system where folks could file a claim for benefits and just put the world on notice of their dispute to a petition for benefits system. It is a much more detail driven process, and it's much more limited in terms of the parties to just put someone on notice. It is jurisdictional in nature, unlike a claim. So if you file a petition for benefits in this state, that's going to start the ball rolling, and we're going to move it towards a resolution, either through mediation, a resolution, or a conciliation or adjudication. We get efficiencies from that because our statute, and part of that that revelation or that change to petitions, we require an awful lot of detail in the petitions. We require substantiation for some of the benefits, not all of them, but we're looking for calculations. Not only do you think the average weekly wage is wrong, but why do you think it's wrong? Not only do you think you're entitled to some medical benefit, but why are you entitled to that medical benefit, and who said so? For example, on our petition for benefit process, the claim for medical has to be accompanied by a prescription from the recommending physician. And we require that there's certification in that process. With the petition, they're certifying that they've attempted in good faith to work out the issues ahead of time. We'll come back to that when I talk to you about volume in a few minutes. When we do motion hearings or motion process, we expect them to likewise talk to each other before they file the motion and bring us into the mix. It is our steadfast belief that most issues can be resolved amongst the parties if they communicate with each other effectively and in good faith. So we've built that into our system. We require it. In addition to the 31 judges I've already mentioned, I've got 30 mediators spread across the state. At one point we had 31, and the mediators were teamed one-on-one. Each judge had a partner mediator. We lost 4 mediators in the 2009 budget cycle. That had to do with the bubble bursting with the real estate investments and things. And so the budget had to be cut across the state. We lost 4 mediators. We have slowly been gaining those positions back, and currently we're almost on a one-to-one parity again. I think that's important to mention because I brag about the fact that we've got an awful lot of citizens out there for each of our judges, but the fact is we've got a mediator virtually for each of our judges also, and those mediators absorb an awful lot of the workload and an awful lot of the responsibility for dispute resolution and issue resolution. So we're going to go through and talk. We probably should have had a question page here, but I didn't throw one in. But again, if anybody has questions at any point, feel free to pipe up. I'm going to give you a survey of our volumes and how things tend to move through our process. The orange bars in this, I didn't realize till I just now noticed, this horribly Florida Gators. I didn't go to the University of Florida, folks, but for some reason I put it in blue and orange. I'm sorry for that. The orange bars in this graph indicate when our legislature or our courts have done something significant that might affect our volumes. That first one in 93, 94 down there, that's when the legislature instituted the petition for benefits process. That major legislative reform was for one purpose, and that was to decrease the volume of litigation in workers' compensation. And if you can say that with a straight face and look at the upward slope that followed after that, We went from 38,000 petitions or claims filed that year to 151,000 when it peaked out in 2002, 2003. You might be willing to conclude from that that the legislature did not accomplish its goal of decreasing disputes. The 2003 reforms, I think most would also agree, began this sort of ski slope downward, and we saw petition volumes drop, we saw dispute volumes drop, and that continued reasonably uninterrupted until our Supreme Court in 2016 made some findings about our attorney's fee statute and limitations on claimant attorney's fees. And when those limitations disappeared into the ether and we got a lot of doubt in our system as to what attorney's fees could, would, or should be, we started to see those petition volumes start to edge back up. The petition volume numbers would probably be higher in a couple of those years, but unlike those lucky folks that are watching that are from such places as Wisconsin and Minnesota or Pennsylvania, we seem to every year have a natural disaster, a hurricane, come sweeping through the state. And when you dig down into some of these numbers in the last couple of years, they would have been somewhat higher, but for the months that we had very slow production after one of those hurricanes hit. So I'm going to focus for you on just a couple of those numbers in just a moment. This gives you an idea that even though they're nice smooth lines on that ski slope, we have had years where the numbers have gone odd directions, and so we have had both increase and decrease. It has not been as consistent as maybe you would think that trend line might work out. At this point, does anybody have any questions about those numbers, where they come from? We're harvesting those numbers automatically in our database when a petition is filed. So all of this data that comes out in that annual report, if you decide that you'd like to read it, and by the way, if you're thinking of not reading it, I would recommend you download it anyway, maybe print it. First of all, because I've got some good friends in the paper industry, but second of all, if you keep that annual report on your nightstand, it is absolutely guaranteed, with just 5 minutes invested of your time each evening, to put you solidly to sleep, and hopefully you'll sleep through till morning. So our process involves the filing of that petition, that jurisdictional document. That's going to bring a dispute into the OJCC venue. There can still be disputes in the claim process that I mentioned with the Division of Workers' Compensation. Within 130 days, we're going to bring that to mediation, and that sounds like a nice long extended time period, but I'm going to illustrate for you in a minute how that 130-day opportunity really is about a 60-day opportunity. We're going to get it to trial generally within 210 days, and after the trial occurs, we're going to get you a final order, a trial order, out in about 30 days. The statute says within 30. An awful lot of our judges do it much more rapidly than that. Are these goals reachable? Last year, for the first year since those statutory parameters were put in the law, on average, every one of our judges and mediators hit those goals across the board. Now, does that mean every mediation was within 130 days? Absolutely not. But if you average out each mediator's year, each one of them had an average well below 130 days, the vast majority of them below 100 days. So we move these cases through the system. The point is, we're here for disputes. So if it's not really a dispute yet, we would hope and expect that the lawyers would not file petitions and get the process started. The thought is, once they file the petition, the process is started, and we have an obligation to move it through the system for the benefit of the two parties that really matter. I say this all the time, and people think I'm being maybe a little too centered, but the fact is, the employees and the employers of the state are who we're here for. We're not here for the doctors or the vendors or the lawyers. All of those are ancillary to our system, and we certainly respect and appreciate their participation, but we're here about employees and employers, and that's who we're trying to provide service to. So when a petition is filed on our website, we will have a petition for benefits show up on the online docket. Any of you, if you go to the website that I showed you, you can click on case search. You can pull up any case that's in our system, and you can have a look at this docket and see what's going on and when things started and how they're progressing. That's all public information here in the Sunshine State. If you didn't know, we have very, very liberal government and the sunshine requirements here. And so virtually anything that happens in government becomes a public record. And so we would get requests if we didn't put this information out there where people could go and look at it on their own. We would spend inordinate amounts of our time trying to produce that information for folks that would like to look at it. So our thought process is that we put it out there and let the chips fall where they may. Just because you can see something's filed, however, doesn't mean you can open the document. Within the document there may be things that are privileged, and so we give you the ability to view the case and see its progress, but we don't give you access to the privileged information. Within a few days of that petition being filed, we're going to publish on the same website when that mediation is supposed to occur. We're not going to send out a notice. We'll get to the due process in a second, but we publish it up on the website because we want the lawyers to be able to look and see that this mediation is proposed for June 17th, and it's got a start time at 3 o'clock in the afternoon. And what we're looking for those attorneys to do is to log in after they either file or receive a petition, see what the computer's proposing, and if they don't like that date, my goodness, give us a call and we'll move it. We do not require a motion or anything in writing to move something before it gets noticed. And so the point of this process is to engage the lawyers early and get them to engage in the process and manage the process. Pick a time that's convenient for them so that we can get on with it. Here's that 60 days I was telling you about. The 40 days here at the beginning, we're precluded by statute from sending out a notice for 40 days after the petition's filed. So that petition in this example is filed March 30th, and we have to wait until May 8th before we can send out notice. Not before we can put it on the docket like I just showed you. It's there and folks could make their decisions and reschedule. But for 40 days it sits there, and then we send out a notice. And your first question is probably, why are you sending out that notice on Tuesday, May 12th instead of Friday, May 8th? We process those notices automatically, our database does it, on Tuesdays and Thursdays. So anything that happens after Thursday morning is going to go out the next Tuesday. Anything that happens after Tuesday morning is going to go out that next Thursday, and that keeps us in a process. The result of that, because we like to give 30 days notice, is that notice that goes out on May 12th is going to stretch out maybe to as early as June 11th, probably after that, and our 130-day limitation is still binding on us, so that in this case results in a 57-day window. Best case, it's going to result in about a 60-day window. And so although we have that 130 days and it sounds like a lot of time, we really don't have a lot of time. We have to be pretty compressed and pretty quick. At that notice date, when that notice is generated and it goes out, the database is going to look at our system and see if there's a mediation scheduled alone, it'll send out a mediation notice. If in that 40 days the judge's office has gone ahead and scheduled a pretrial and a final hearing, then when that notice goes out, the computer will pick up all three of those and send out what we call a three-way notice. Different judges feel differently about it. I personally like the three-way notice because I feel like it gives the parties more notice that their trial date's coming. It gives them a 6-month window to get their ducks in a row and to focus on some day that's coming up when they're going to get a chance to tell their story. Other judges like to wait until after that mediation occurs, maybe in mid-June, and then give notice of that final hearing and when it's going to occur. The downside of that is without that sort of persistent reminder that trial's coming, we have seen instances in which folks just don't get ready. They don't do the work to get prepared. Unfortunately, when that happens, we get motions for continuance. We get folks that are in a tight spot with their clients, and that can be troublesome as well. Just the imperfection slides are really for your sake in the written materials. I'll go just through one of them as we proceed through this. Anytime we go to comparing numbers, it's going to be a bit imperfect because it takes that 210 days perhaps to get to trial or 130 to get to mediation. So if the mediation in this instance is going to be held on July 1, that's the first of our fiscal year. Our fiscal year runs July 1 through June 30. So right now we're in the fourth quarter of 2020. So if the petition's filed in a previous year and gets mediated in a subsequent year, then comparing those petition filing volumes with the number of mediations or the outcome of mediations gets a little bit dicey. So we're not really positive in terms of those numbers, And so I just give you this as a caveat as we work through these numbers. What do we report on? Our mediation settlement report each September is going to give you the volume of mediations held. We're going to crack it out in terms of each of the potential outcomes for mediation and what's happened. We're going to give you the total volumes, like here, the 17,000 that we had in 2018-19. We're going to tell you whether it's increasing or decreasing. We're going to tell you how our mediators are doing in terms of the 130 days. And we're going to tell you what's happening in terms of getting those cases off the book before mediation and sometimes even after. So that report is a snapshot for the folks in our legislature that we look to for funding to try to keep this system on track and on course. And it helps us to explain to them why we need the people we need and the other resources. One of the things they're always very interested in, because it's what they tend to hear about from their constituents, is continuances. So we always report on the volume of continuances, and we keep some statistics as to why those cases are being continued. Is it because of a bankruptcy of a carrier that leaves us no choice? Is it because of an appellate issue that's removing jurisdiction from our office? Might it be from a natural disaster? Those things we do like to keep track of. So remember here I told you about the ski slope of the numbers, and what I want to focus on as we go through this comparison is really right down here, because again those would be the years that might be mediated in the 2018-19 time period. It might be a petition filed that year, it might be the year prior, and so I'm giving you both sets of numbers. Those two numbers, 70,295 and 73,146, reasonably close. But they could skew the numbers if we weren't talking about such large samples. So those numbers representing the volume of petitions, that's what comes in the door in a general sense, keeping that caveat in mind. And before we can even get them to mediation, about 17,000 get dismissed. That means the lawyer that filed it or the party that filed it reaches in and pulls it back out of the bucket. 16,000 or so get resolved or settled before the case can get to mediation. So the dismissal, all we know is that they're withdrawing it. The settlement or the resolution, they're telling us why. And about 5,000 go to private mediation. Our state mediators, I think, are some of the best going. The problem we have is they are all high volume, and so some of these folks would rather have a private mediation to get more time, or they'd rather have a private mediation because the mediator will come to them instead of them having to come to one of our district offices. However their preferences work out, that means that a pretty significant volume, if you will, are falling off of our process. That's leaving between 32,000 and about 34,500 petitions going to mediation. I already told you we had 17,056 mediations, so you run that math out, and we're running an average of about 2 petitions per mediation. So that tells you that the mediator, who's got about 45 minutes to an hour in most mediations, has got an awful lot of talking to do, comprehending to do, teaching to do, to bring these cases forward and to make the parties conceive or understand why they should or could resolve the issues or the case. We categorize our outcomes in 5 different ways. If the case settles, that means the resolution of not just the pending issues, but all future potential issues. Settlement of the case, some states call them washouts. Notice a very high volume of our cases that get into our mediation system resolve in settlement. The others are partial. The all issues resolved is, I know it's partial, but I say all. It only resolves the pending issues. So that means that the rest of the forward-looking history remains open for the injured worker, and she or he might file new claims or new issues in the future. The others all resolved except for fees or the sum issues resolved. All of those represent some forward progress in the case. I'm a big fan of the sum issues resolved. When I talk to mediators, private and state, I stress the value of the sum issues resolved. And a lot of folks look askance at that and say, why are you shooting at the low one? Wouldn't you rather have a settlement or a complete resolution? I don't have a problem with those resolutions, but I'd like folks to remain focused on the fact that if we can get something resolved at mediation, that is particularly beneficial, I believe, mentally, for the injured worker and the employer. They get to see some progress that's perhaps not a monumental decision in terms of settling the case or resolving all the issues, but monumental in the sense that they see forward progress. Maybe they get that doctor authorized. Maybe they get that MRI taken. Maybe they get some feedback on return to work. And those things can help build communication and I think ultimately lead us up to the grander resolutions of all issues are settled. Now, we also have a pretty high volume of impasse, which means nothing gets resolved. I'm pleased that as our petition volume has climbed, you see that the impasse levels have actually dropped. And so you would think that as petition volumes increased, maybe more cases would be, I'm not going to talk about it today, I can't resolve it today, I've got too much on my plate, and we're just not seeing that. So frankly, that's something we're proud of, and I think we're making a good service to our clientele, which is our state citizens, in having that kind of a result. Anybody at this point have questions or resolutions? Well, I can't get inside the head of the legislators that put that in the statute, but I can tell you what many of them told me. They told me that they were informed by industry that if industry had an opportunity before the petition for benefits was noticed for mediation and clogging up their calendar, if they had an opportunity to resolve the issues, that they would be happy and willing to do that, and they thought it would be productive for them to have a time period, a waiting period, to get those issues resolved before we started sending out notices. They saw it as a resource allocation opportunity. I think some carriers actually engage in that and do a good job. I think that's part of the reason why we have that high number in terms of the resolved before mediation right here. 17,000 being dismissed before mediation tells me that folks are working at some degree in trying to get those resolved. Now, whether it's before we get it noticed or not, I can't say. But that was the idea behind it. So, okay. Our pretrial discovery is very, very robust. We allow depositions, requests for production of documents. We do inspections of premises or entry onto land. Really, the only tool that we don't afford the folks the opportunity to use is interrogatories or requests for admissions. There are some lawyers that use depositions on written questions, which are contemplated by our rules. Other lawyers will object to that and argue that they're interrogatories, but it does happen some. All cases have to be mediated before they can get to a judge, subject to one very narrow caveat. And so folks will go private, that counts, or state mediation. Once they've gotten their issues mediated, then they can get on the trial calendar or they can get the case to trial. They did put in one little escape valve that if folks do not want to mediate, they can file a motion to waive mediation. Those do not go to the judges around the state. Those all come to my desk. I'm the sort of sole arbiter of that escape valve. I'd have to pull up the numbers to tell you for sure, but I'm pretty confident telling you that it was less than 20 that I granted last year out of all of those. I'm a big believer in mediation. We may not have a lot to talk about, but I think most of the time there's something that we can talk about when we get together. And again, I think it builds relationships and builds communication. That number could probably be calculated out of our database, Judge, but I do not know what it is off the top of my head. We get the impression that an awful lot of cases that go to private mediation tend to at least resolve all pending issues, and the reason we get that anecdotally, we think is because people are paying money out of their pocket at that point to go to the mediation. And we all know that, frankly, we just all are better at following through on things when we've expended our own resources to do it. Okay. Back to the old dragnet shield, just the facts. So I culled out the names. If you want to get the names, you can dig out those annual reports. But just to give you an idea of the spectrum of how our folks perform in mediation, last year, the 2019 annual report shows that some mediators had a 17% impasse rate. Others had as high as a 42% impasse rate. So across the board, our average is about 26% of cases are impassing at state mediation. The resolution of either all of the issues or anything short of the smaller one, the sum issues, we have mediators that are hitting as high as 68% resolution rates. Others, the low is about 40%. So it gives you an idea. Folks ask me all the time at the Capitol when they're talking about budget dollars and things, does mediation work? And these are the numbers that I pull out because I don't think there's a rational argument to be made that mediation doesn't work in workers' comp. I think it works, and I think these numbers prove it time and time again. Does it have problems? Is mediation perfect for comp? I don't think anything's perfect for anything. So there are issues we run up against that are troublesome, but I think overall it's very effective. That's just for your information, the imperfection of data. When we get to the end of the process, 2018-19, my judges conducted 633 trials. And your first reaction should probably be, boy, that's just not a lot of trials. I don't disagree with you. Why do we have a low volume of trials? I would suggest to you that if judges are doing a good job of being consistent, both internally and in their writing about why and how they're deciding cases, if they're consistent and predictable, I think lawyers tend to reach out and resolve their own issues with one another. They get a pretty good feeling for where a particular judge is likely to go, and they can, with that kind of knowledge, that predictability, they can solve their own problems. If we take the petitions that were left over after we do the math to pull out all of those that resolved, it comes down to essentially about 1% of the overall population of petitions ends up going to trial. And that's true regardless of the numbers. I've given you those same starting numbers, that range that we worked on. And so the fact is it's just a very small percentage. And here's where they kind of fall out. From that petition date, okay, we're going to get this to mediation. The filing, and here's what falls out before, is about 53 to 55%. So most petitions are falling out before they ever get to mediation. My mediators will tell you that they think that's because they are consistent and predictable also, and they think their predictability lends itself to folks having a pretty good idea what they're going to hear at mediation, and so they pick up the phone beforehand and talk to each other, and that may well be the case. The rest of them, the other 43 to 45%, are falling out after mediation but before the final hearing, and my mediators will tell you that that is because they did such a great job at that mediation that when folks went home and had a chance to sleep on it and eat on it and reflect on it, that they decided to settle anyway, even though they didn't get it done at the mediation. And you can decide if all that's true, but my mediators would likely beat me black and blue if I didn't mention that they think that they're responsible for most of our success. I think that we've got a great group of mediators, and I do believe mediation in general is responsible for a lot of our success. We went to mandatory mediation early. We've been in the game now for over 25 years, and it's been effective that entire time. Any other questions at that point? About 1%. That 633 is going to be about 1% that we're drafting orders. Now it's possible some of those will go to trial, and after the trial, but before the order comes out, the parties will resolve the case. But I can tell you that happens maybe 3 or 4 times a year across the whole system. So I'm comfortable with the 1%. Well, and we're similar to that. Our attorney's fee statute was a percentage that set forth 20% of the first 5,000, 15% of the second 5,000, 10% of the rest, with some other little caveats that aren't really important in the accounting game. That statute was declared unconstitutional because it was an absolute limit, and so in 2016 our Supreme Court said that that limit does not apply. They steered us back and said we should be giving reasonable fees paid by the employer carrier if they have resisted. And reasonable is defined by the Supreme Court's proclamation of what they thought was reasonable in terms of analysis, not amount. But they said back in 1968, here's the factors you should look at. So in 2016, they pointed us back at those factors they think we should look at. Our Supreme Court in 2004 published an opinion where they said under the separation of powers doctrine they had no authority to make rules for this office. And then in 2016 they published an opinion and said if you're granting fees paid by the employer carrier you should follow our rules from 1968. I'm not sure how that shakes out or if it'll ever be challenged, but that's happening. In the claimant paid fees, that same formula was supposed to limit the attorney's fees. That decision of our First District Court of Appeals about the same time as the Supreme Court decision is read by many as totally freeing up those percentage guidelines and not applying them. And so I can tell you just from numbers that we generate at the end of the year that we have claimants' attorneys who are taking as much as 40% or more out of an injured worker's settlement when the case settles. And we have attorney's fees on the other side from the employer carrier, hourly fees being paid that are as high as $400 an hour. So it's really a great mixture, and a lot of different things are going on. It would be hard to answer the question any more clearly than that without a specific case to use. We leave that entirely up to the mediators. Many of them will send out emails to the parties ahead of time asking questions. You know, I've read this in the petition, I've read that in the response, and they try to engage. We have others that don't engage until the actual mediation itself. And then we have some who after mediation will actually follow up in a week or two to see, you know, I thought this was going to go somewhere, I thought you were close, anything I can do to bring you back into the fold, shall we reconvene, that sort of thing. But it's really just kind of across the board, and it depends on the mediator and his or her calendar and availability. All right, great. So just a sketch of the filing volumes, and I'm trying to stay on target with our time here. So our electronic filing volumes, we rolled out electronic filing in 2006. The numbers go back before that just a little bit into the calendar 2005, but that's our 2006. And what we did was what we call a soft open in the software business. We published the availability of electronic filing on our website. We didn't tell anybody that it was there for them to use, and the geekiest amongst us got in there and played with it and used it and helped us to find where it was deficient or broken, helped us develop it, and in the spring of calendar 2006 we started promoting, and these are the numbers. Yeah, you can see last year we had 601,000 documents come in through our electronic filing portal. That is really critical to what we do, because in our system I can be in Wisconsin, I can be in Saskatchewan, I can be in Berlin and do everything that I can do sitting right here at my desk. I can hold hearings using a program like Zoom. I can access the full panoply of pleadings that have been filed, the arguments, all of it is at my fingertips. Last week I heard a state mention that they had figured out how lawyers could upload trial exhibits. We've been doing that for, gosh, an awful long time. Every trial exhibit gets uploaded by the lawyers in our cases. Our electronic filing is coupled with electronic service, and so when something is uploaded either by the parties or by one of our offices, that is automatically served. Another reason why I could be in Berlin producing orders, because I don't have to find a post office or have stamps or even a printer. We convert the order to a PDF, we upload it to our docket, and it automatically serves.
a little bit of bragging. We're saving our marketplace. Our best estimate is we're saving our marketplace right at $1 million per year in postage just from the electronic service component of this package that we've built. The employees, we came along in 2011, and so you see this chart right here in 2011, our legislature mandated the use of electronic filing. And so it should have gone up dramatically at that point. We were rather surprised when it didn't, and that told us that through our voluntary efforts we had managed to drive the marketplace to being appreciative of electronic filing. They were using it already, and it was doing a good job for them. So those volumes, I think, speak volumes in terms of what we've done and why we've gotten to where we are. Before I take any questions, I'll just mention right now I've got mediators that are mediating from home, and they also can access all of that information and data from anywhere, just like me. And so that's helping in this particular crisis for them to do their job remotely. Any questions pending? And it's rock and roll songs going through my head now. No reply. No reply at all. Okay. All right. So what are we doing in the world of COVID-19 or however you're referring to it in your jurisdiction? Coronavirus and the pandemic. Everybody's got different vernacular, and that's fine. We're trying to stick with COVID-19, but I've gotten some criticism for that. What have we changed? About 28% of our folks are currently telecommuting. We don't have a single office closed, although some of our landlords have told us that the public's not allowed in the building that we're leasing from them. So we're keeping the public out in 3 of our locations, but for the most part we're open and doing business as normal. I know somebody out there, one of the lawyers in the group, probably somebody like Judge Marshall, is going to say, gosh, you should sue your landlord because that's probably a breach of the lease. And we've talked about that, but at this point in time, really, we think we've got better things to do with our time than worry about litigating, and we're getting the job done for folks without having the public have access, and so we're going to just stay the course and keep doing the people's business. On March 14th, I suspended all in-person mediations. We mandated them to go by telephone. There's a change from your PowerPoint. We've changed that now to May 17th. Before everybody started coming in from the waiting room, there was a general conversation amongst the organizers about everybody being in a wait-and-see posture, and we're no different. We're waiting and seeing, and we kind of get every once in a while another 2-week extension or something that we're going to keep doing things differently for the time being. Our hearings, we've gone to telephonic and Zoom over the internet. We have used some GoToMeeting and some other similar platforms. A lot of people very nervous about Zoom. The main hang-up that we're finding with Zoom is that we have injured workers who are A, unwilling to leave their homes. They're fearful of the atmosphere. And B, they're telling us that they do not have webcam capability in their homes. We always ask the lawyers when they say that to just verify, are you sure they don't have a smartphone or a cell phone that'll transmit a video signal? Is that the way we want to hold a trial? It really isn't. Do we think we can hold a trial? I think it sort of depends, and that's why we've left the decision in the discretion of the judges. Is this a one-issue trial where we're talking about whether a new doctor should be authorized or an MRI should be ordered? Or is this a 42-issue trial that's going to have 17 live witnesses? The more complex it becomes, I think the harder it may be to do it on Zoom or similar. And so we're leaving that decision to the judges. The only other rule that we've suspended in the midst of all this is we had a requirement that child support affidavit be submitted with every settlement. We backtrack everybody's child support before we'll approve a settlement. We have databases to look at what the state says about who they might owe and how much, but we've always required that affidavit too. Has to be notarized, and the complaint we got from the practitioners was really hard to get the claimant to come in, really hard to get a signature notarized. Couldn't we do it differently for the time being? And we agreed and acquiesced with that. Our legislature, this time last year had just passed a bill. We have internet notaries now. That law became effective January 1st, where someone can hold their ID up to the camera and show this is me, and the notary 1,000 miles away could notarize their signature because she or he sees them do it, or could swear them as a witness. The problem is, just happened January 1st, and then this thing kind of bubbled up on us pretty quickly, and an awful lot of the folks that are notaries have not done the certification training to be an internet notary. So while some law firms have that ability and are ready, others don't, we thought it best to suspend the rule. If you ever get the chance to advise your legislature, I really suggest that there's a great deal of merit in this internet notary idea, because it really does allow this kind of interaction, and I think would facilitate. So overall, I think we're business as usual. Why have we been able to maintain continuity? Again, it goes back to the electronic filing that gives my judges and mediators full access anywhere at home on their iPhone. They get full access to the case, and they can move someone's issues forward. The electronic service so that they can contact the parties and do things without having to have a post office or envelopes or stamps or all of that just further effectuates that. Our greatest attribute, and the thing I'm probably the most proud of over my tenure in this job, is that we don't talk about my case and your case anymore. We've got folks that pitch in. We've got a real team, and that's judges, mediators, and staff alike across the state. I've got folks pitching in from 400 and 500 miles away to pick up a hearing or to do somebody's file uploading, and that is all because we've got a team attitude. And so what you can do to encourage that in your environment, I strongly encourage. So what's happened here more recently? I just thought I would show you the COVID effect. Our petitions, the red line is the trend line. So if you look at our third quarter, the first 3 months of calendar 2020, it looked like things were going pretty reasonably consistent. When you just look at March, the filings for March were down 2% over last year, and that tells us there was a start of a slowdown. So we ran the numbers for April, and in April, the petition filings are down 22%. So okay, not 22%. I reran the numbers this morning. If you look at the first 26 days of April, our petition rate is down 30%. So that is significant in any frame of reference, keeping in mind where we're going to see the effect of that is 130 days from now when we see the mediation volume drop, and 210 days from now when we see those cases not particularly ready for trial as a result. That just summarizes, you can read that. The net effect on filings, again, the first 3 months of the calendar year, our third quarter looked pretty consistent, looked like we had standard growth at about 3%. In March, you look at the March numbers, we saw a decrease, and there again, you look at the first 15 days of April. I didn't rerun these for you, but we're down about 10% across the board in terms of what's coming in. And so is COVID-19 having an effect on the way we do business? Not so much the manner, but it's affecting the volume, the workload. My fear is that means that COVID-19 is affecting injured workers and employers who have disputes out there that are not being brought to our attention, and thus we're not getting them resolved like we'd like to. So again, that just summarizes that. And that concludes. I've given you my email address here in the PowerPoint. I'm always happy to respond to emails. Always happy to respond on social media. We've got social media up on all kinds of platforms, and we're trying to keep the public informed of who we are and what we do. And with that, I'll throw it back over to you for any more questions, and if none, then I've kind of wrapped it up. What kind of system? I'm sorry? POTS. POTS. I don't know what that is. I'm sorry. Oh, our electronic filing? Our electronic filing we built from the ground up. We started in 2001. We deployed the actual filing piece for our offices in 2003. We deployed it, as I said, for the public in 2005.
Our total investment to date in our electronic filing and service package is right at about $1.4 million overall. So not a huge investment if you want to build one. If you don't want to build one, but you like what we've got going on, it's all open source. And so any state that wants it and wants to adapt it to their own purposes is more than welcome to take it. To my knowledge, there are at least 2 other states that are using pieces of it, at least for their foundation, as they moved into an electronic world. So we're not selling it, but you're welcome to it if you want it. It's very, very hard to answer that question. My legislature asks that every year. And the reason that it's hard is because our system only counts what someone's status is at a moment in time. It takes, none of the kids understand this, it takes a snapshot. So I can tell you as of July 1st how many cases were unrepresented, but I can't tell you how many of them filed unrepresented. They may have had a lawyer that filed those petitions and then the lawyer withdrew. Well, when the lawyer withdraws, they'll show as unrepresented even though they were put together by a licensed attorney. By the same token, a claimant may file unrepresented petitions and then get a lawyer, and those would then show as represented. So with that caveat, each year we take that snapshot on June 30th, and each year it comes out to be about 3% of claimants that are not represented as of that date. The best answer we've got. Well, we have an order that closes all non-essential businesses. He first tried telling the restaurants to limit their volume of customers. It was an every other table restriction, and we weren't seeing the flattening, and so he closed down everything that's non-essential. Pardon me. A lot of argument here and elsewhere about what is essential and what isn't, and we're struggling with those things too. But no, tanning salons are not open. Bars and restaurants are only open for carry-out. I didn't misspeak. Bars are open for carry-out. I kid you not. We have retail stores open. It's nothing like the experience we've seen in some other states where stores are limiting what you can buy. If the Walmart's open, you can buy anything that the Walmart has. Many of them are limiting volume of people in and out the door. And so some supermarkets, for instance, have door counters, sort of like the folks you've seen at Disney World that count how many people are going to get on the ride. And they're only allowing so many people in the store at one time. And every time someone comes out, someone else gets to go in. But generally speaking, I think our retail and restaurant business is reasonably open for business. And a lot of people are laid off because they don't need the same volume of employees. One of my fears is that when that changes, those old employees that got laid off may go to new employment where they could get work in the meantime. They may not come back. And the statisticians tell us that new employees tend to have more accidents. Lack of familiarity with the job or the premises, that's when we tend to see spikes. I'm really hopeful that as we get back to work, we don't see a spike in accidents and injuries. See, that means I either did a really great job of covering everything or I just left everybody completely in doubt that I didn't give him even enough to formulate a question. I don't know. Not at all. I enjoyed it. Not at all. Thank you. I'm going to. No, I'm happy to. Thank you.